All right, well, thank you everyone for joining us today with NAMI Greater Cleveland for another one of our community education webinars today on the topic of estate planning for people with disabilities. I'll allow our two guest presenters to introduce themselves momentarily, but just wanted to get through a few orders of business with you all first. So again, please do note this is being recorded and will be uploaded to the NAMI Greater Cleveland YouTube channel later this week. So just be mindful of the recording if you don't want to be on camera or may ask any questions that identify any personal information. A few other things, please note there are no CEUs for this particular webinar since it is not on a clinical topic. Please do remember to remain muted during the presentation so we can limit distracting background noise. Please also utilize the chat feature if you have questions. We will have at least a few minutes before we wrap up by 1 o'clock Eastern time to have time for Q&A. But we also may address questions during the presentation. And please also stick around with us when we wrap up. I'll be dropping a link to a survey about this presentation in the chat with you all. We appreciate your honest feedback on our programs as always. Many of you are likely familiar with my name and my face if you've attended many of these webinars already and are familiar with NAMI Greater Cleveland, but just know that we are a resource here for individuals living with mental illness and their family members in Cuyahoga County, and we're happy to provide programs like support groups, our helpline services, and also educational presentations like today's webinar. So with that being said, I think I will hand it off to Dawn McFadden and Christina Bushnell to introduce themselves and get us started. Thank you all for joining us today.
Hello, hello. Let's see, we're going to need to be unmuted.
We can hear you. You're good.
Oh, you can hear us? Okay.
Yep.
Hello, I'm Dawn McFadden, and I'm here with my sister,
Chris Bushnell. Thank you so much for inviting us here today. We do appreciate it. We are going to be speaking today on estate planning for people with disabilities. A little bit, though, first about ourselves. We are two sisters. We have a firm that focuses on elder law, special needs planning, estate planning, guardianship, probate. And we are in Shaker Heights, Ohio, and generally serve the Northeast Ohio region. We started our firm 2016, so we've been doing this for a while. But we're going to kind of focus today on a little bit more of a focus on some special needs type planning.
So the basis of what we're doing to start with is certainly just the basics of estate planning. So whether this is for an individual with special needs or a disability or anyone, a lot of the documents we're talking about are things that we think everyone over 18 should have in place. And we're going to talk quite a bit about that.
And that age 18 is an important milestone in a lot of people's lives, but before someone turns 18, the parent is the natural guardian of that individual, of the minor, and can make decisions. Once they turn 18, they should either be doing their own planning documents if they can, or if that's not possible because of capacity, competency issues, perhaps guardianship is something that needs to be looked at.
So we're also going to talk about public benefits and special needs trusts, guardianships and conservatorships, and then have time for some Q&A as well.
So first off, why plan? Why is planning of this type important? First of all, for individuals who may have disabilities, one, having this type of planning can provide some financial security for people, particularly those on benefits. Doing this planning may allow the best leverage of benefits as far as being able to get means-based benefits such as SSI, while also having some extra funds to supplement care. It also makes sure that we have a proper team in place to support that individual, both while perhaps a parent or loved one is here, but also after they're gone. Plan for appropriate housing. Make sure that there's an ongoing system of advocacy in place. Oftentimes, you know, an individual's parents are their biggest advocate. What happens when that parent is no longer available or able to advocate? Plan for potential future caregiving needs, coordinate efforts of family members and chosen family as well, not just biological family, but often they have chosen family that can help with that. Protect a beneficiary, protect an individual from creditors and from predators who are looking to take advantage of someone. And then also perhaps preserving assets for an heir or other individuals.
So what happens if you do no planning? And that's something that, you know, we only have about 50% of people in the country who have any planning in place. So let's talk about if you haven't done planning. In that case, you would be covered, or that individual would be covered under the laws of intestacy at the time of their death. That means the state is going to determine how things should be divided. The state is going to define who the family is that they're including. And those are, again, in Ohio, specifically defined in the Ohio Revised Code.
And some people think, well, the state will get everything. No, the state doesn't get everything, but the state does define who gets things. And sometimes it may be how you would leave things. Sometimes it's not. So, for example, if there are stepchildren who you want to provide for, intestacy doesn't really provide for anything going to a stepchild. I mean, really, the only way it would go to a stepchild is if they cannot find any heirs in order to give it to. It would potentially go to a stepchild. So if you want to make sure that you get to dictate where things go and who makes decisions, you need to be putting some documents in place.
Now, there we're talking about at the end of life, after you've passed on, what happens. But there's a number of documents that we think are incredibly important, again, for anyone over the age of 18, and we're going to talk about those. So we've got wills and revocable trusts, or different types of trusts that can determine what happens at death. But during life, it's incredibly important to have things like a durable power of attorney, or a financial power of attorney, a healthcare power of attorney, a living will, and a HIPAA authorization. And we're going to talk more about those.
So first, a will. So the nice thing about a will is you get to say where things go. You get to designate where things should go and where things shouldn't go. If you have minor children, that's a document where you would say who you would want the guardian of those minor children to be. We will also at times put in that document adults who may require guardianship. And oftentimes that parent is acting as the guardian of their adult child. We will put in there, for any child of mine, even an adult who requires guardianship, this is who I would ask. And the court has said, we talked, and this is in Cuyahoga County, we talked to the judge and we said, is that helpful? Because it doesn't automatically happen. The judge is the one who will determine who the guardian is. And the judge said, you know, it is helpful to see what that thought process is. Who would the parent make? It helps to guide our decision. It allows you to pick who would be in charge of your estate. That's called an executor if you have a will. It's a public process, so the probate court oversees it. Sometimes that's good. Sometimes having the court oversee everything, particularly if there's some question about whether everybody's going to be on the same page, having a court overseeing it is not a bad idea. And as we had stated before, if you don't have a will, the state of Ohio will determine how things get distributed.
So the pros, you get to decide who's going to get what and who's going to help play the key roles. If you fear family members fighting, this is a way that you know, again, as Chris said, that there's going to be a judge overseeing the proceedings. And it could be a good way to provide for the transfer of minimal assets, or where largely assets are passing outside of probate. Doing transfer on death for your bank accounts, for IRAs, and you can even do that for houses and vehicles.
And what some people don't understand is probate is only the things that you haven't determined to go elsewhere on their own. So if you have beneficiaries listed on your health insurance or on your life insurance, if you have your bank account has a transfer on death on it, if your homes, either you jointly own them and with a spouse or someone and it has a joint right as survivor, that won't need to go to probate. It goes automatically to the other person. People can even do a transfer on death for houses. So there are ways of avoiding having to go through probate without a will. But anything that does not automatically go on its own where it needs to go at your death will have to go through probate.
Cons, it's a very public process. For example, in Cuyahoga County, anyone can go onto the probate court's website and see who died, if somebody has died, who is showing up and claiming they're owed money, who were the beneficiaries, who is inheriting what. Sadly, this can make people subject of trolls. And if you think you already get a lot of calls about people wanting to buy your house, wait till you're named as an executor in an estate. You'll get even more calls from people who want to come in and sometimes take advantage. It can be a very long process. It doesn't offer long-term creditor protection for beneficiaries that you can do with trust planning. If trusts need to be set up, they may remain under court supervision if that happens under a will. It can be an expensive process. It's often less expensive to set up the will up front than it is to do a trust, but the costs overall tend to be more with doing probate. And it doesn't provide for incapacity issues during your life. If you became incapacitated, your will doesn't come into effect until you're gone. But that's where some trust planning can make sense.
So revocable trust planning. So
revocable trust planning is something that we work with a lot of families to do. And this is a way that you can set up a way to manage your assets during your life. You can also provide for protections for your beneficiaries when they pass. They could leave funds in that trust and be protected, or they can, depending on how you set it up, take funds out. It's a way to avoid probate. It puts protections in place for your beneficiary. We typically are still doing a will with that with the revocable trust, but we're just pouring things from the probate estate into the trust to be distributed according to the trust. It is less to be fully effective. It's important to make sure the trust is funded, and we'll talk a little bit about that.
So the pros of having a revocable trust is one.
Oh, sorry. Jumped ahead there. I'm trying to do a little organizing behind, but give me 1 second. There we go.
Okay, so the pros is one, it provides creditor protection. When we're doing revocable trust planning, it for the beneficiaries, not necessarily for the person who's setting it up, but for the people who will inherit from you. If they end up in a bad marriage, if they have a bankruptcy, if they get sued, if the funds are in trust, it's protected. It allows for distributions over a longer time. So often, if we have someone who, if we have somebody who maybe would be taken advantage of, but maybe doesn't need a special needs trust, we can create what's called a spendthrift trust. So they don't automatically be able to access things, but assets, but they could be provided by the trustee. Sometimes though, it's okay that distributions theoretically could go to that person, but maybe it's a younger individual. They're a teenager, and we don't necessarily want everything going to a 20-year-old. We make better decisions at 35 than we do at 20. So maybe on a trust, you'd say, okay, they can get 25% when they're 25, and they can get 25% when they're 30, and they can get the rest when they're 35. It provides for the person creating that trust for their incapacity, that someone could step in and make these, help make these financial decisions regarding this trust if they become incapacitated. And now IRAs have to be paid out in most circumstances, not all circumstances, but within 10 years. You used to be able to stretch payments out when you inherited an IRA over a lifetime. Now, in most circumstances, it needs to come out within 10 years. So it may make sense to have it go into the trust where it can be held instead of coming all outright quickly to an individual, depending.
Now that 10 years, the two key exceptions that are important for people to keep in mind is, number one, transfers between an IRA to a spouse can still be lifetime. Also, if it's going directly to an individual with disability, they may also be stretched over a lifetime, including into a trust for that person. But for most people, for most typical younger children, that we're going to be looking at a 10-year distribution.
Excuse me, is there any difference between a traditional IRA and a Roth in terms of distribution timelines?
I don't believe so.
I don't think so. But the difference is with the Roth IRA, you've already paid for those taxes. When the other ones, you still have to take them out, but you're going to be paying those taxes over that shorter period of time.
That change was under the Secure Act. And so that's certainly something you could just Google a little bit. Just search Secure Act, 10-year distribution, Roth IRA. It's going to give you some good information. And it's a good thing to speak with if you have a financial advisor, to speak with them about. Sometimes it makes sense to look at converting some traditional IRAs to Roth IRAs in light of the Secure Act.
Thank you.
Yep. All right.
So the cons of a revocable trust is they do tend to be a little bit more expensive when you set them up than will-based planning. And you have to be able to name somebody to be a successor for you when you're no longer able to do that. One of the things, it's a little bit more expensive to set it up, but then theoretically you can avoid having to go through probate, so it becomes less expensive then. And I say theoretically because in order to avoid probate, you have to make sure that everything is either in the trust or directed to go to the trust upon your passing, so that everything ends up in your revocable trust.
We're going to jump to some of those other non-estate, those powers of attorney documents, but we're going to come back to special needs trusts. So don't worry that we're moving without spending much time on that right now.
Could I ask you just one quick question?
Sure.
When you had mentioned like a con about a will and that the public nature of it, and how if someone passes away in the house and getting those calls, is that protected then with the trust more? Is it more private then when you have a trust versus just having the will?
Yeah, it's both. One, nobody will know other than the beneficiaries what's in that trust and how it's distributed. With a will, it goes to the probate court. You can go onto the court docket and look up the person's name and look up the inventory and see what assets are there. You can't do that with a trust as long as there isn't fighting over the trust that throws it in a probate court. But theoretically it can be done, and it can be done a lot more quickly. You don't have to go through the whole court process in order to start acting on what the grantor wanted to have happen with their trust.
All right. So we're going to talk about documents that all adults with capacity should have. We're going to start with talking about that durable or financial power of attorney. So this document is incredibly important. This allows you to designate someone who can make financial decisions for you. You can designate whether it's going to go into effect immediately as soon as you sign it. And we'll often see that maybe if an older person is coming in and they want to make sure their kids can step in and help right away. Or you can say, no, I'm good for signing now. It's only going to be if I lose capacity, then somebody would be able to come in and sign. Without such a document, if somebody becomes incapacitated, you're likely looking at having to get a guardianship. Again, going to the court, and the court will be involved for the entire process and ultimately the one making decisions.
And here in Ohio, they always look for the least restrictive option. and a power of an agent acting under a power of attorney is less restrictive than a guardianship. So if there's one in place, typically the court will defer to the power of attorney.
An important thing is that the power of attorney can also be used to name the guardian of minor children. So a lot of people may think, well, I have a will in place and I've named the guardian there. Well, that's good, but that's only if you're gone. If you became incapacitated and could not take care of your child, that will doesn't come into effect yet. That's where in this document we can say, if I'm alive but incapacitated, here's who I want to take care of my children. And again, as Chris mentioned earlier, we would even list for adult children with disabilities or special needs to let the court know who you think would be the best person to serve next as guardian.
So the next document would be a healthcare power of attorney. It gives legal authority for someone else to make decisions about your health care. Unlike the financial power of attorney that can be effective immediately or only upon incapacity, the healthcare power of attorney is only upon incapacity, or in that if you are able to say what you want, if you have the capacity to make decisions and to be able to convey those decisions, then you're the one that makes your healthcare decisions. The nice thing about this too is it prevents the courts from being involved if there's a disagreement between family members and or if family members and what doctors say that they would want to have happen. And you know, one of the things, and we've come across this not too long ago, is some people say, well, I'm going to name multiple family members to be my healthcare power of attorney. And you certainly could do that. That can be problematic though, because what happens if one family member strongly believes that they want a course of action and the other one doesn't? Sometimes it's better to list that one person.
I'm going to answer one of the questions that just came up in the chat. Is there a national database of attorneys who specialize in planning for people with disabilities? I wouldn't say that there's a database, but there is a group that we're actually members of called NALA, or the National Academy of Elder Law Attorneys. And those are attorneys who focus on both elder law and special needs as being part of elder law. So if we're looking for attorneys elsewhere in the country to make referrals for, the first place we always look is we go to the NALA website and we search for that area. So it will show you if there's some people in that area who are able to help. And I'll put their website up in the chat.
Just as far as,
there we go.
As far as attorneys who work in this area, you'll often see there's kind of attorneys kind of stay in their lane often and have their own specialty. So attorneys like us, often you'll see elder law attorneys who are also doing this special needs planning, which it often, the reason that is because a lot of the elder law planning is trying to plan for Medicaid and planning for long-term care. Well, some of those same issues are involved with people being eligible for SSI and Medicaid and other plans like that. So that's why you'll often see that overlap of attorneys that do that. However, oftentimes the attorneys who are doing that type of estate planning and special needs planning are not necessarily the ones that are going to help apply for Social Security. That's kind of its own little area. Just answering that question about the difference between a durable power of attorney and a financial power of attorney, those terms are interchangeable.
Durable simply means, durable is a way, and we say this in our documents, by saying it's durable, it means even if I become incapacitated, I still want this to remain in effect. So it's not just now when everything's good, it's even when I become incapacitated. So that's where you'll hear that term. One thing I think that's worth mentioning, and especially with the healthcare power of attorney, is a lot of times we may have situations where parents have been able to advocate for and speak for their children with the healthcare providers, and the doctors have listened to them, even if they are not acting under a guardianship or acting as a healthcare power of attorney. We'll talk a little bit later in the presentation about how if an individual with disability or special needs has capacity, it's a great idea for them to set up these documents so they can say, these are my people, this is who it's okay to speak with my doctor. We want to caution people against, especially if they have young adult children, feeling we don't really have to worry about this because our doctor talks to us. Because often we'll see a situation where the doctors say, you know what, we really can't anymore. You are not, this is not a child anymore. They're over 18. And that's where getting these documents in place before you're hit that kind of a wall can really make a big difference.
Seems like sometimes where we see that is there's been a doctor that they've worked with for years and years, and then that doctor retires. And when the new doctor comes in, suddenly, there's a new sheriff in town. And that's often where we'll see the problems arise. So one of the things to keep in mind too, Ohio has what's called a Declaration for Mental Health Treatment. We have the Ohio Revised Code. You can just Google Ohio Revised Code in that section and it'll pull it up. But it specifically addresses mental health issues in a way that your typical healthcare power of attorney will maybe only touch upon. So that individual in moments of competency and capacity can say, these are the decisions that I would want to have. These are things that I'm okaying. This is the person who I'm naming who can be my proxy. They can revoke it as long as they have capacity. And it's one of those things that every 3 years that they should be renewing it. One of the things, it does have to be notarized and or two witnesses. And I'm going to see if I have my next page. So here are some of the things that a person can do. They can say what they will okay and what is not okay according to them. So as far as medications, as far as treatments, whether and what facility they're approving. Same thing with physicians. These are physicians or therapists that would be okay. This is my therapist, or I do not want to be treated by X. So it's a way that perhaps people who have some mental health issues can, when things are going a little more smoothly, they can put these in place.
We're going to talk a bit about guardianships and a little more about some of the questions that came up there, but I do want to respond to one of the questions that says it's better to have a guardianship makes it easier to deal with some agencies. And I'm going to push back a little bit on that. The question really should be, does the individual we're talking about have the capacity to make their own decisions? Are they able to understand these type of documents? And if so, then the documents that should be used are the durable power of attorney, the healthcare power of attorney. And that is because if we have capacity, we should not have to be subject to a guardianship where somebody else is appointed to make our decisions. I am certainly not taking away from the fact that I know it can be very difficult to deal with these agencies. And some of it is a matter of working with an elder law attorney, a special needs attorney who can help make sure you have robust power of attorney documents that make clear that you have the capacity to represent your loved one before those agencies. And sometimes attorneys need to get involved to kind of fight a little bit to say, no, we don't need a guardianship in this situation. We have these documents in place, and under the law of Ohio, it should be the least restrictive means possible. But we can't always do these documents. People aren't able to always sign these documents, and we may need to deal with guardianships. And when we do, then that's fine. But it's a much more onerous process, and it's something that you're then required to do court filings on an annual or biannual basis, depending what county you're in. But again, if you have a financial or durable power of attorney that is suitable and is getting the job done, you should not need to have a guardianship.
Although sometimes with just that caveat, you may have a perfectly valid power of attorney, financial power of attorney, for example, and a bank just refuses to deal with you. Well, sometimes then it's necessary to get guardianship.
We may even be able to get a limited guardianship. We may go to the court and say, court, this power of attorney is fine, but XYZ is fighting on this issue. And the court may say, all right, bank, do what you have to do. And we're not revoking that other power of attorney.
It's got to be a kind of a balance, because each option has its benefits and each option has its drawbacks. So there's not a one case fits all.
Hey, could I ask a question about healthcare, not so much the financial side, but when it comes to these powers of attorney and guardianship? So say you have an adult family member that has been deemed that guardianship is needed. But this person, given, this is a NAMI audience here, so they would have mental health conditions where they don't believe that they have a problem. How do you essentially make healthcare happen? What happens when they refuse and they say, I don't want to see a doctor, I don't want to take medication? Does the guardianship or the healthcare declaration for mental health treatment allow services? Like, does it essentially force them to go see a doctor? Does it force them to take medication? When do things stop and start is what we don't understand.
Yeah. So I'm going to try to answer that a little bit. Unfortunately, there are times where we may have those strong powers of attorney and do still need to get a guardianship. And you've just given a perfect example of when that might happen. We may have a power of attorney that says, hey, healthcare facility, I get to make these decisions now. They named me when they had the ability to name me, and I'm the person now. And facilities may say, we are not getting into this fight, and we need a guardianship before we're going to move forward. That's why in these documents, you'll see the language that says, well, I don't need a guardian. If one is needed, I want the person named in this document to serve as guardian. That allows you to then go to the court with those documents and say, while there is a healthcare power of attorney or a financial power of attorney, same situation might happen. Court, please appoint me now to serve as guardian. The other documents aren't working. The least restrictive didn't work anymore, is not working anymore. And now we will have to go with the guardianship.
But then again, if that person refuses treatment or doesn't want to do anything, does the guardianship give you that ability to have treatment occur? And then how do you get that to occur?
So you may need to make motions to the court asking for the court to order treatments. And at that point, because ultimately too, under guardianship, even if you're the one that's named as the guardian, really the court is the guardian. The court is what they refer to as the superior guardian. So you are acting as the guardian on behalf of the court. So it may be that the court needs to be more further involved in those situations, and it may be necessary to make a motion to the court and ask the court to intervene.
And there may be some facilities that are not willing to work in that situation and there may be other facilities that are more able to deal with somebody who is resistant of treatment, and they are going to have to use more restrictive means. Obviously, that is last preference. We want to make sure that we're giving everybody the opportunity to make their own healthcare decisions, but sometimes there does need to be that intervention.
Yeah. So if guardian says yes, you must take medication, patient family member says no, and doctors say yes, but patient still says no, what happens?
We are not healthcare providers.
Right.
So it's hard.
Understood.
My understanding is that guardianship does not allow, you can't force someone to take a medication, even if you have guardianship over them. That's my understanding.
The court, I am thinking, is going to be reluctant to do so unless there is a threat of harm to themselves or others. If there's immediate harm to others, then the court is more likely to step in.
But we're likely then looking at more of an inpatient situation. So I don't think it may be helpful to talk with someone to let them know that you're under guardianship and I have been appointed your guardian, and we think this is the best idea. But yes, you're not going to be able. Somebody is not going to be able to come and say, well, we're going to force them to take the medication other than as Chris described. So In addition to the healthcare power of attorney, another document we prepare is something called a HIPAA authorization. And this is where under the healthcare power of attorney, you're saying who could make healthcare decisions. This is another list where you could say, well, these are people that if I was in the hospital, if I was getting care, these people could talk to my healthcare providers and get information. This can often be a longer list. This may include people who aren't the decision makers, but are people that you would want to be involved.
The living will is a document. Sometimes you've seen it referred to as advance directive. It allows you to make that wishes known for end of life decisions. What we say is this is the document that is either you're in a permanently unconscious state. Some states will refer to it as a vegetative state, but you are not going to be awakening out of this, or terminal. And terminal doesn't mean I have 6 months to live. Terminal means you have hours, days to live. That's when that document will come in place. And it allows you to say at that point, I just want to be made comfortable and if two doctors agree that I will not, that I am in one of those conditions, it's okay to just make me comfortable. And it's really helpful, I think, one, to make your wishes known, but two, it can help relieve guilt from family members who maybe wouldn't know what an individual would want. And it's saying, okay, at that point, it's okay to let me go.
So we're going to talk now a bit about public benefits, special needs trust, and stable accounts. We're doing a quick run over just what the kind of framework of the public benefits are, so we can spend a little more time talking about trusts and stable accounts.
So in talking about means tested public benefits, meaning they're looking at your income, they're looking at your assets. The program associated with that is SSI, and the medical program associated with SSI is Medicaid. The entitlement benefits, which is SSDI, that doesn't have the same sort of income asset limit to it. And it's based on an individual's work history. And after a period of time, then Medicare will be the health program associated with. And we're going to touch on a couple other things too. So SSI, supplemental security income. You do not need to have worked to in the past in order to get SSI. You have to meet two requirements. You have to be medically disabled or elderly, and you have to be poor. There's a resource test that's done once at the end of every month, and there's an income test. So what is disability? That definition varies from whether an individual is a minor and when they become an adult. So for a minor, the term that they use, the conditions that they have is that the impairments causes marked and severe functional limitations. And that's to be expected to end in death or to last a minimum of 12 months. For an adult, the definition changes to that inability to engage in any substantial gainful activity. Basically, can that individual work? So someone who so at that point, there's often, even if somebody is on SSI as a child, they get a redetermination when they turn 18. And for a lot of people, they may not even go through that initial determination until they're an adult. So for the resource, the individual has to have $2,000 of countable resources. For an individual, it's $3,000 for a couple, and not all resources are counted. So an individual can have a home, an individual can have an automobile, they can have personal items. There are certain burial plots, certain funeral policies, irrevocable funeral policies that are allowed. So there's some things like that. And just to back up for a moment, as far as those assets go, before an individual is 18, their parents or resources, their parents' assets are counted. That's another reason why a lot of times people don't apply until they turn 18, is because their parents have too many assets and their income is too high. When the individual turns 18, they're kind of judged on their own standing.
Stable accounts are really a wonderful tool, and they're something that a lot of our families use. These are new. These were in 2014 that they first became available. And under Ohio, they are referred to as stable accounts. They create tax advantage investment accounts for individuals with disabilities, and any funds that are in that stable account are not countable assets. That makes a huge difference. Where before, if somebody were to get some amount of money, they would feel the need to quickly spend it down so they were still eligible at the end of the month. If they have a stable account, they can instead put those funds, which is limited on an annual basis, into a stable account and then have those funds available as needed, not quickly going and buying 3 TVs so that they still meet eligibility. They're based on the way 529 accounts are set up. It provides that financial independence for people with disabilities. The account is owned by that individual with disabilities, but deposits can be made by anyone up to an annual contribution limit. And that annual contribution limit is tied to the federal gift tax exclusion. So this year, I believe we're looking at $19,000 per year. Upon death, the funds in that stable account are subject to Medicaid estate recovery. So we are not typically recommending using stable accounts as place to pack lots and lots of money. It's more of a money in, money out. Let's put the money in if we need to. We can use those for some really good strategic reasons, but we don't want to put so much in that it's going to be subject to Medicaid estate recovery. You can choose how to invest the funds that are in that stable account. In order presently to set up a stable account, you must have been disabled prior to age 26. It doesn't have to have been defined prior to age 26. You could have an individual who at 30 receives the diagnosis they've been working their whole life to get, and they realize it was a disability they had since birth. They could still set up a stable account. Though we are looking in about a year that's going up to 46, and that's going to be a really good change.
So at this point, for example, someone who had a traumatic brain injury at 35 would not be able to set up a stable account if that was the reason that they became disabled.
But after that age change, up to age 46, they would be able to.
So what can go into stable accounts? It has to be cash. Stable accounts don't take like real estate and other items. Up to $19,000. That is the current estate tax gifting limit. So it changes from year to year. If the individual is employed, they may be able to put a little bit extra money in there. Right now it's up to just over 15,000. However, I think that component of the person being able to put their own income in there above the 19,000, I think that's supposed to sunset this year. There was proposed litigation to extend that, but we'll see if anything gets through Congress. There is a limit right now of 541,000. That's the most that can go into an account. And also something to keep in mind, it can build into a stable account or it can build in that stable account. And once it hits 100,000, which takes a while, if you think about it, you can only put $19,000 a year. But once it goes above 100,000, you lose SSI, but importantly, you don't lose Medicaid. And for a lot of people, that SSI is so that that's the entry point to be able to get health care and to get access to Medicaid. And importantly, you don't lose the Medicaid. And once you drop below 100,000, you would go back on SSI. There's a question there about stable accounts or Ohio only. Ohio stable account is Ohio's ABLE account. Every state can have its own ABLE accounts and have different names for it. Ohio was actually the first state to set up an ABLE account, and it was stable. They named theirs stable. And I don't know if it's still true, but for a good period of time, stable account was, Ohio was running other states' able accounts as well. I don't know if that's still the case or not.
And people from other states, they're going to want to look at their state. Their state may have their own able account that they must use, but some states may not have it set up yet or may allow you to use another state. So at the beginning, there were people all over the country setting up stable accounts because they were really well organized and they were ahead of the game.
And you can only have one able account. So you can't have an able account in Pennsylvania and an able account in Ohio. You're only allowed to have one. And some states will allow people from other states to participate in their able accounts. Other states are limited to only residents. So it really does depend.
So withdraw
moves to Ohio from another state and they have a surplus in their able account. What do you do in that situation? I have people that move from New York and New Jersey over to where I'm at. And when they're bringing that money, what do they do if it's over the amount?
If it's over the 100,000 amount, you mean, or that it's
that they just have an account from another state?
I guess if they just have an account from another state, what does that look like when they move here?
So number one, the stable accounts has a really good FAQ site. So I would definitely look there.
Okay.
I would also reach out to them and see. I know that there is some ability now to do Roth IRA rollovers into stable accounts. There may be a similar feature from another state. I don't know for certain. I'm just guessing. That's what I would look at first.
Okay.
Could continue to probably use that state's able accounts. You just wouldn't then also be able to set up an Ohio, stable account, but it may be that the account that's already set up in another state may be sufficient for what you need to be able to do. In most cases, I don't think it's a situation where you can no longer use or contribute to it.
Got it.
Set up.
Yeah.
Okay.
And again,
thank you.
Our recommendation is not that we're parking tons of money there. We're using a stable account for things like, if you use a stable account to pay for rent rather than coming out of a trust, it doesn't affect SSI. So that's a good reason to put enough money into the stable account to pay rent. Somebody has inherited $10,000. They could put that $10,000 into the stable account. But then our goal is to spend that down so that there's as little in that stable account. So in that situation, we might be looking at and saying, you know what, if we've got 5,000 still in the New Jersey account, can we spend that down over the next year and then set up the Ohio account? Again, depending on what makes sense.
Yes, thank you.
Yeah, and each state has their own rules, so it's worth looking at what the different able accounts are. But they can use these funds for what they call qualified disability expenses. So there's all sorts and at least the person who had been in charge of Ohio's program, he's no longer there, but he had a pretty broad interpretation of what is a qualified disability expense. And what's also nice about these types of accounts is the individual can get you can get them a loaded credit card. And so they can have some ability to, use these accounts but not deplete them theoretically. Does an individual's Roth go against? Yes, so that would be typically, yes, an account like a Roth IRA would count towards Medicaid. There's some little bit of differences depending on what stage they are in, but yes. They work well with third-party special needs trusts because, as Dawn just said, if money goes from that special needs trust to pay for rent, it can affect how much they get on SSI. When by design, money can be used from a stable account to pay for rent in the month that it has come out, and it won't affect their SSI. So often we have it so that they're all kind of playing nicely together.
So we're going to talk quickly about special needs trusts. We again want to leave some time for questions, and we're happy to stay a little bit after 1 o'clock to answer questions. But let's get into the special needs trusts.
So there's several different types of special needs trusts, and you kind of have to think of where does the money come from. If the money is the individuals with the disability, they've inherited it, they've earned it, it's in their bank account. Those are all first party money. It's my money. Those will have to go. You can do planning, you can do special needs planning, but that's going to have to be in what they call a Medicaid payback trust. So it can go into that trust. It allows them to get benefits, but upon that person, well, first of all, it has to be for that individual's sole money or sole benefit. And two, at the end of that individual's life, the state of Ohio would be repaid for Medicaid that was paid for that individual. So that's the benefit of that trust. Also with that typical first party special needs trust, and you'll often see it referred to as a D4A trust. That's because that's the part of the federal code that it comes from. It can, again, it can be set up by parents, grandparents, legal guardian, the court, or the individual. But importantly, it has to be funded before that individual turns 65. It can still remain open after 65, but no more funds can go into it.
First party pool trusts are a really great tool, especially if we have a situation where somebody has more money than can go into a stable account, but maybe not quite enough for a first party standalone pool trust, especially if we're anticipating needing a trustee other than the family to be involved. With a pool trust, they're set up with nonprofit. There's a couple in Ohio, and funds are pooled together with other funds. And then that here up in Northeast Ohio, we often hear Community Fund as one of the main pool trust companies, and we've worked with them quite a bit, nonprofit. That way they are the ones who are going to help and make sure distributions are appropriate under the law, maintain eligibility, manage and invest those funds. And knowing that if something, especially if we have parents who are involved who know I'm not going to be around forever, we know that there are good people running these trusts who can be able to continue to do that.
Right now, they can be funded after 65. Mm-hmm. It's kind of unique to Ohio, though. A lot of states don't allow it, and Ohio's legislature keeps talking about doing away with that. But for now, you can.
So the next one is kind of our gold standard, third-party trusts. These are trusts that individuals who are not the person with a disability can set up with their money, third-party money, to benefit that person for their life. So here, for example, we may have parents set up a third-party trust. They can put their funds into it, sometimes during their life, but more often it's where we're going to be depositing funds upon the death of the surviving parent. And those funds can be used for that person with a disability or special needs for their entire life. It's going to not affect their ability to get benefits, but when that individual passes, there's no payback provision. This does not have to go to the state, and instead it can go to other beneficiaries named by the grantors. Often we set these up as being revocable during the life of the grantor, though there are a few exceptions about that.
So the main requirements is the beneficiary or their spouse didn't create this trust. It isn't their money. It's somebody else's money. And also that the trust doesn't hold any of their money. If somebody else set it up, it's important that first party, the disabled individual's money, and third party, the other people who are providing for them, those funds do not mingle. Because if they do mingle, then there's always the threat that it'll be perceived as what they call a first party trust, and the whole thing will be subject to Medicaid estate recovery. So there are times when we will set up both a third party special needs trust and a first party special needs trust. A kid inherits $15,000 from grandma. And so we need to figure that out, and we'll set up a first party special needs trust. But then the parents go, wait, we don't want this to happen again. What can we do to avoid having that payback, and we will set up a third-party special needs trust.
I want to quickly address and not address a comment there that says funds taken from trusts are taxed as used. That I don't believe is a correct statement, but we're not going to get into a lot of taxing here. Funds in a trust will be taxed according to tax laws. If you mean like an IRA where funds are taxed as they come out of a traditional IRA, that's true. But different types of trusts and whether the trust is revocable or irrevocable, going to have different tax issues. And you're definitely going to want to work with a CPA who is experienced in helping with special needs trusts.
Guardianship, we're just going to touch on this one too. So again, guardianship is a legal means for appointing someone or a party to be legally responsible for another person. It's overseen by the county probate court of where that individual is a resident. Typically before 18, that parent is the natural guardian of that child. It's not necessary to get guardianship generally. After 18, it may be necessary. So what are the types of guardianship? Well, there's guardianship of the estate. This is often the day-to-day decision-making, health placement, etc.
Skip past this because we're getting to the end of, and we don't have too much time for questions. And we've shared these slides with Matt, who's going to share them with you. And I think that may just be a good one to read on your own. So some of this is stuff we've already talked about, guardianship versus conservatorship. We don't really see conservatorships used in Ohio. We're not going to talk too much about that.
Because typically if some conservatorship, someone can elect to be, it's for individuals who have capacity, although it's overseen by a court. And at that point, you might as well have a good power of attorney to serve, to achieve that purpose. Some states you'll see it's interchangeable as far as what they will refer.
Are there more questions?
Or can we go back and touch on something?
That's right.
In the last couple minutes and further go through.
Yeah, I noticed a couple questions in here. Can an adult now disabled get a stable account if their illness developed in childhood, but they weren't disabled until adult age? If not, is there a comparable program for adults?
So there is not really a comparable program for adults. What I would suggest is going through these with the stable account, you self-certify when you're setting that up. They have questions to ask if you meet the requirements. I would just answer them in a way so that obviously still being truthful, but it doesn't have to be when was the disability diagnosed, but when did it start? And if you can answer those questions and establish it in such a way that disability should have been diagnosed earlier, you may well be able to still set that up.
You'll see that sometimes, like, for example, with autism diagnoses, that maybe they weren't diagnosed or that they didn't reach the level where they necessarily were looking for benefits early on. Well, they had autism going back to birth. That isn't something they just developed when they were in their late 20s.
There was another one here. Quickly review Medicaid qualifications and assets. Not really in a minute, I'm sorry, other than typically you need to have to qualify for a lot of the Medicaid that we work with. You have to have under $2,000 in countable assets, and that's typically we're looking at bank accounts, investment accounts. You can have one house and one car, and those don't count. But if you have a second house, if you have a second car, those count towards those $2,000. And income, there's different rules with income. And even if your income is above a certain amount, you may still be able to set up something called a Miller Trust and qualify for Medicaid, even if your income is higher.
And it kind of depends too, because Medicaid have different programs. There's nursing home, paying for nursing homes. That's often what we'll see with older individuals. Sometimes there's different community-based Medicaid programs that don't have the same asset limits, but have income limits. There's other Medicaid programs that will help pay for Medicare premiums. Those have asset limits that are different than what they call some of those waiver programs. So it really does depend on the program.
As to caregiving needs and housing needs, to some degree, generally that was talking about why we do the planning. And that is because we're wanting to make sure through trust planning, through power of attorney, that you are creating that team who can help you with all that. We certainly we're not thinking we'd be able to get into in deep discussions and all of that. One great resource, and this is one many of you are probably already familiar with, is the Milestones website. They have some really great information on housing, on different caregiving, on different things, as well as connecting for kids. Those are two places that I would definitely go to their websites, and they might have some helpful information.
And the Milestone, their focus is autism, but there are a lot of their resources kind of can go beyond to other disabilities as well. Am I missing?
Did we miss any, Matt?
I noticed one. If a guardian establishes a special needs trust for an adult child, can they designate a future trustee or guardian upon their death?
So typically a guardian isn't setting up a special needs trust, though they might be. Often it's a matter of the parent is, well, I guess a guardian could.
But yes, usually a guardian will have to be getting permission through the court in order to do that. And often, yeah, you could name someone to be what they call a successor trustee.
That's definitely the case with third-party trusts when parents set those up. Sometimes they may be naming other family members to serve as trustees, but there's also some professional trustees, and sometimes that's a better way to go, because that way, instead of naming siblings to serve as trustees, siblings can serve as siblings. They may serve as advocates and let somebody else who is in this space all the time serve as a trustee.
Right. I think that covered it. Just want to remind everyone to complete the survey for this presentation. We thank Dawn and Chris for covering a lot of ground in 60 minutes. And again, I will be sharing these slides with everyone in a follow-up email, so you can look for that in your inbox from me. And again, we're also recording this, so you can review everything that was shared and covered in this session. It'll be uploaded to our YouTube channel later this week. Thanks everyone for joining us.
Bye.